All right, here we go. Hi, this is Kurt Barone,
And Brad Pinsky.
and we're here for another edition of Philo Roundup for February 17th of 2025. Brad, go ahead. Take us
Okay,
away.
I always start off by saying this week we have some really interesting cases. You just pick interesting cases. Unfortunately, the world delivers us interesting issues.
It writes
Um,
itself.
it really does. And I don't know how you ever limit it to five a week, but nonetheless, this is another good week of, very different types cases. So let's start in Seattle, where firefighters. Now, I have a question about this, which I'll pose at the end because I'm not 100% I understand it, or maybe they are missing a fact, which I'm looking for. But they claim firefighters have filed a class action lawsuit, meaning they represent a lot of similarly situated people with the exact issues and exact type of damages. And they allude, or they claim that the new payroll system that's been added is miscalculating things like sick time, overtime, pay rates, their incorrect deductions from wages, incorrect leave accounts, incorrect leave deductions, incorrect withholding of deferred comp, and failure to properly pay out deferred comp. So they say that the city knew it, and they claim that the city has failed to correct it, and they're still using the system. So here's what I'm questioning. So my first question is, does the city knows it, but there's some allegation, or they allude that the city's actually corrected the problems, but hasn't corrected the software. And so that's what I'm not sure of. It looks like they were, because they say, the class says, we were forced to spend hours identifying and attempting to correct errors. So that's my question. Did the city agree the errors are wrong, or they have not agreed? Because if they haven't corrected the errors, I don't care why they're making them, right? Except it's going to be continuous. They made them, and they got to fix them. If they were made and erroneously, and the errors were fixed before there was any problem, like we paid you the overtime, we made up any difference, whatever, then just suing because you have crappy software, that's going to be a tough suit,
Oh,
unless it's a
I think
repetitive.
this, yeah, I think this is going to be a really easy suit, honestly. And I think what was happening was they were doing the different things wrong, but one of the things they're doing wrong was overpaying. And then when they overpaid people, then they took the money back
No.
in one of the subsequent. And there's actually statutes, state statutes, and also local ordinances that regulate what you should do when you make an overpayment and what you can do. And if you,
Right.
let's say you overpay somebody $1,000,
Can't
you
just
can't
take it
just,
back.
right, you can't. I mean, you can over a course of time, but you can't just. So there's actually state laws. And what I think is the ultimate irony here is the city of Seattle, which is, pretty well has a reputation for, being
Progressiveness.
well, being considerate to workers, okay, and to the point where they have a higher than state um, minimum wage. They have a higher than federal minimum wage, so they really are pro-employee, and they actually have, which I think is really unusual, that the city has its own ordinances that dictate when people have to be paid, how frequently, or how many days after the close of the work week you have to pay, and all that. So they have gone way and above what most municipalities do. Like most municipalities here, they rely on state law. They don't have their own. Seattle has seen fit, because they care so much about employees, that they have their own wage payment and wage theft laws, and the city violated them. And,
Well,
and
not intentionally
it
necessarily,
doesn't
right?
matter. You know what?
Oh, I agree.
Here's the thing. If this was some big box store, and I don't want to, identify a big box. I use the euphemism Walmart,
Right.
not to be mistaken for another big box store with a similar name. But if Walmart does this, they violated the wage theft law. They've stolen from their employees. Maybe they only stole for a week or two or three, but you still violated the city's wage theft law.
But if you've
So this,
corrected it, the damages are zero.
I don't know that. You'd have to get in there and look at the cases, look at the history of it, look at how the city interprets it, and so on and so forth. But the city cares so much about employees that they've enacted their own laws to prohibit
Right.
what they are actually doing.
The reason,
It's
though,
it,
I think this is harder is because of the one of the lines in the complaint, which is although the city of Seattle has insisted they're attempting to fix the program,
Mhm.
the violations are ongoing. And I
Mhm.
could see the judge practically saying, listen, you can't just stop using a program because then you have no way to collect the information, right? And presumably the
Well,
city saying, listen, we recognize it's a problem. We're working with the
yeah.
vendor. They're trying to fix a program, but we can't just take it out and have nothing.
If this was October and they implemented this in September, that would be one thing. It's
Right.
February, and they implemented this in September. And by the way, I've been contacted by a number of firefighters who are saying our city is using the same software and it's nothing but a disaster.
Right.
And I think there are allegations that there are other cities out there that are using this that have had similar problems speaks to possible negligence in terms of implementing this system. And I'll give you my opinion. I don't know this specific software, but I do know computer companies have some brilliant, genius coders who develop this software.
I know.
Okay.
Yes.
But the software doesn't necessarily align with the law. And you would think that the genius programmers would develop a system that's going to align with the law.
Right.
Well, apparently the geniuses do it the way the geniuses want to do it. And maybe they're saying, well, you know what, the law ought to think about it the way that we think about it. And you have this, right? And you have this
Right.
problem.
Right.
Because there's just too many cities. Again, several people have contacted. One just within the last half hour emailed me
Wow.
saying
Okay.
my city's using it and it's a disaster and there's mistakes. And so I think what needs to happen is the programmers, either need to get some lawyers involved in teaching them what is required. Again, it's to me, it's the classic tail wagging the dog, where we're trying to get the system to do, what the
Right.
law and it should have been programmed right from the get-go
For the law.
to comply with the law.
Yeah. No, agreed. I think, if I'm the city, I'm reading my hold harmless or releases of liability clauses with the software where they say we make no guarantees. Probably you have to, of course, that's legal stuff that if they're not paying attention to the law anyway, maybe the software company doesn't have any of that in there. But I
Well,
would
I'm
be
sure they
looking
promised them the world. You and I have been around the world enough to know I'm sure the software company promised them the world, and they
delivered
just,
nothing.
yeah.
Yeah, but
So,
I do agree with you that I think the continued use of a program while subjecting it to liability, I see the court argument. Judge, if nobody's going to get paid anything, we're working with it, we'll pay the difference, we're correcting it. I
yeah,
don't
but
know.
then the judge has got to go, aren't you the same person who is dictating to all the other employers in your city that
Right.
you have got to do it in compliance with the law or you're going to be penalized?
Yeah.
And
Yeah.
now you're saying, well, we need a little accommodation. Well, there's no accommodation that's built into the law that you
No,
enacted.
it is
And
strict
plus there's
liability.
also right. And also there's a state law on the same point.
Yep.
So again, I think really the software and again, my hat's off to the geniuses that can program these types of systems. It truly is. But at the same time, you can't do it in a way that's going to be convenient to the programmers. It needs to be in compliance with the law.
Right. I will tell you I'll tell everybody a funny story without mentioning it, but as some people know, I started a large software company
Mhm.
and sold it, many, many, many years later. And I remember having a conversation with one of our programmers who had been with us for 14 years. They'd been programming our software for 14 years. And they said, so what is it your software actually does? I'm like, you programmed this thing and you don't know why it's used? They're like, no, we really don't know why you use it. I'm like, but that's the mentality of the programmer who says, well, I know what you told me you wanted to do. I just don't
Uh,
know why. And without understanding that next portion of it needs to adhere to the law. How
yeah.
does the program, not the coder, but the system engineer who designs it, how do they tell the coder how to code it? right? You know, when you cross 40 hours on this type of week, here's what happened, blah, blah, blah. So,
And then there's a disconnect between the marketing people and the people who know how the system works. Okay. And marketing is doing what marketing does. And, it's just, there's a disconnect there. So,
well, I'd be suing the software company if they haven't. That would have been my first thing to do, because they caused the issues. I don't care what release there is. They marketed it to do something, and it's breaching its warranty of its commercial viability warranty. Okay. Let's go to, we'll stay with the S's. Let's go to Sacramento, a little south of Seattle. They've settled with a former fire chief for $300,000. This is also interesting, right? Because we've covered this.
You remember, I don't know if you remember it. I
had to look it up. I had to look it up. But I do have some questions for you on this. So they settled, this is Chief Gary, I don't really know how to pronounce his name, Loesch, or Loesch.
Yeah. He was a chief in Philadelphia.
Oh, wow. Okay. So, big department, good department. So he was hired in 2018. He had a long career with the Philadelphia Fire Department. He alleged that the city manager not only wrongfully terminated him, but then intentionally, this is interesting, exposed him to COVID. That's the part I didn't understand, in retaliation for having challenged earlier discipline. That's the part I don't get. Is this like the old chickenpox party? We're going to take you to get chickenpox at the party?
I don't know. That part of it was not fully explained. So I would imagine there must have been a meeting, and someone at the meeting, was not feeling well, and subsequently may have had COVID. I don't know, but I think there's a lot of factual questions here. According to Chief Loesch's allegations, he wore a certain costume that apparently offended the city manager. And then there was some other things that were, there were some allegations of a hostile work environment or some other things in the department. And apparently the city manager wanted to suspend him. And I don't know what Chief Loesch told him, but one of the things we just were discussing at our FLSA conference is that when you're on a salary, your salary cannot be diminished. What can happen is if they diminish your salary by giving you unpaid days off, there's the potential that you no longer qualify for the executive exemption, in which case you're entitled to overtime and hourly and so on and so forth. So that may have been what he said. I'm not 100% sure, but he apparently told the city manager that, you can't dock me. And that in turn led to the city manager saying, we're going to fire you.
Right. And look, this goes to a point you and I have made, right? The discrimination is bad in discrimination cases. This isn't one of those, but the retaliation portion of any suit is worse, because that's intentionally vindictive. And I think, I haven't done any study on this, but I would bet the retaliation portions of the claim pay much higher than anything else under it. Now, this is a pure retaliation claim, but retaliation, I mean, look at this. This is $300,000 just for retaliation. And here, there's no discrimination, anything else. Retaliation is big money, and this is a settlement, not a jury verdict. So it's even lower, presumably, than he might have gotten if he won. So people got to be real careful. Do not retaliate against somebody ever.
Easier said than done, but absolutely, I agree with you. I agree with you. We call it, the claim that even a first-year law student can win. It's so easy because you don't have to prove the truth of the underlying allegations. All you have to prove is that you made a complaint, which he did, and subsequently there was some sort of adverse impact. Being terminated would qualify. You've got a retaliation claim teed up.
And you said easier said than done. You're right. I've had these conversations, but I'll tell you what I've said to people, because they're like, he's getting under my skin. He's doing this just to get under my skin. He's doing it to piss me off. I said, no, he's not. He's doing it so you'll screw up, and then he can sue you, and then he's going to get under your wallet. He's going to get under the mattress where you hide your money, right? He's going to get everything, he or she, whatever. I said, so what you don't want to do is ever retaliate, because that's what they're looking for. That's what they're pushing you to do, right? Saying things and doing things and making complaints. There's no action there. You retaliate. Now they've teed it up. You've teed it up for them. Game over. And I try to calm people down by saying, don't give them that satisfaction. If you want to get under their skin, smile, shake their hand, thank you for their complaint, investigate it, and come out with a fair outcome.
Right. Absolutely. Absolutely.
I suspect in all the courses you take, that's kind of where they want you to go, right? They're trying to lead you down the path.
Yeah.
Okay.
Absolutely.
Anyway, that was great. So, now we have Muncie. This is also interesting. I read these and I'm like, Jesus. So we have a Muncie fire captain suing. So it's just the allegations claiming that he was improperly denied a promotion. He was a fire captain. And we covered this in at least three separate stories, but I want to remind everyone of the outcome. So there was an allegation, and I think you and I took different sides to this. I'm not sure. And we got a lot of emails from people about this.
And we can debate that part of it too, is what is cheating? If you don't clearly delineate what is cheating, you can't really accuse somebody of cheating.
And what he did was he collected the test questions from people, which happens all the time. Hell, most of them are in a book, like the fire everything exams, fire instructor exams, fire officer exams. There are sample questions in the book, but they're the identical in either verbiage or content. They're identical questions you'll see on the exam.
The LSAT prep, right? The prep to go to law school, the prep to go to med school. I mean, it's all based on previous questions.
And there's only so many ways you can ask a question that determines if you have the information needed, right? So you know what information you want to test on. There's only so many ways you can ask that. Even more limiting than LSATs, MCATs, GREs, which, are kind of theoretical. But these fire officer 1, fire instructor, EVOC, whatever it is, EMT is testing on specific knowledge. So what he does is he gathered the test questions and he handed them out to people and reviewed it. He didn't give them the answers of this, although there was some allegation about leading group discussions during the exams. In any event, he loses all of his credentials. So he's no longer able to be anything in the fire service. He had no credentials, which was, by the way, I think really overbearing losing your credentials to teach is one thing, but losing your firefighter certs and all that, and name it, that gets reversed. It gets reversed by an administrative, right? But the penalties get reversed, not the findings that he did something wrong. This is where I have a problem with this lawsuit. So he claims he was denied a promotion and says, well, look, the findings, everything against me was reversed and I should be, I was number one on the list, and the city has a policy where they take the number one on the list except for exceptional circumstances. But here's the thing. He wasn't found innocent. It was just that the determinations of the penalties were overturned as too harsh, but not what he did wrong. And even though I don't think he did anything wrong, it doesn't matter. That's not what the ALJ said. And he was determined to have done something wrong, though not justifying the penalties. So I don't know that he wins or loses on this. I'm just suggesting, you did something in the conduct of your employment that we found wrong. I don't think we have to promote you on that. And I think a court's going to say, this is just my Monday morning quarterbacking, I think the court's going to say, I'm sorry, they still had a valid reason not to, right? Because we don't have to rule on whether what you did was wrong. That's already ruled on.
Well,
and so based on that.
And I think if he can get the court to consider the merits of his case, which...
And I don't think he will.
Exactly. But if he is able to, then he's in a better position to move forward and prevail. If he's not able to, and res judicata and collateral estoppel, he's probably going to be stuck with those previous findings. But we'll see. I mean, maybe he will be able to get to the merits of what he was doing. So
yeah, I'm betting, look, discrimination, if it's based on a reasonable belief or whatever, I think that the court's going to say, we do not review the city's allegations of what he did de novo. We're not going to review them as if we were the appellate court, because those findings have already been reviewed under a separate process. All we're going to do is say, was it reasonable based on those findings to the city to take that action? And they're going to say yes. I have a hard time believing they're going to say no, but what do we know?
Who knows? Who knows? It'll be interesting to see. I was out in Indiana last week, and there was a lot of discussion, kind of off to the side, about this particular case and is it cheating? Is it not cheating? And some interesting debates about it. But at the
And
end of the
we
day,
we got emails from both sides of the story. Somebody going really after him, right?
yeah.
Saying that's not what happened. He was
Mhm.
cheating and blah blah.
Mhm.
So I don't know. I wasn't there.
Yeah,
Right?
I
We
don't
weren't there.
know either, but again, I think we take the 50,000 foot view here. If you're responsible for any sort of testing process, you can't after the fact say, oh, that's cheating. You need to say ahead of time, this is what's permitted, this is what's not permitted. Okay. If you have a prior exam, you're the person who administered the exam, you are not permitted to use that information in any way. Okay, fine. I was the proctor. I can't use that information. Obviously, I've got the test and I've got the answers. I can't use it in any way.
That's in
But
writing, sure.
right, but if I'm just an instructor, I don't have that. And I query my students who work for me, they work for my department. I query them, what questions did they ask? That's a little bit different unless it's prohibited. If it's prohibited, then so be it. But I think there's not enough. It's easy after the fact to say you shouldn't have done that. And if it's so obvious, then why don't you have a rule ahead of time that allows people to understand what's permitted and what's not?
And there are Freedom of Information Law and Freedom of Information Act cases about tests, and the
Yeah.
tests before they're given are not subject to freedom of information. But
Mhm.
the test, once you give it to the
Mhm.
public and
Mhm.
anyone can take it and it's
Mhm.
open, are no longer protected unless there's great reason to, are no longer protected information because the people weren't sworn to confidentiality who took it. They can talk
Mhm.
about the test questions all they want. They could have sat there and took the test for no other purpose than writing down all the questions. There's
Mhm.
nothing wrong with that. It's a public exam. You're not sworn to confidentiality.
Yeah, and
I
the other part to this, and I just from personal experience, we have to take periodic exams, whether it's the CPR or EMT refresher, and many of these are hazmat, right to know, all these, periodic, annual, check the box types of quizzes. And there's a distinction we need to understand there's a distinction between those we're just going through the motions here because it's I've been in the fire service 52 years. That means 52 years worth of annual CPR 50 question exam.
right.
But at the same time, that's different than other types of certification exam, whether it's for promotion, whether it's to be a hazmat technician or so be it. So there's a distinction there. And I don't think we're all that clear sometimes on where the boundaries are.
Yeah. Well, I think the boundaries are where the writing says it is. And if you're not given any boundaries, there are none. Right. I mean, but I don't see how they could be legitimate either. Now, how could you tell someone you can't talk about the test you just took? Come on. Okay. The next one I so strongly disagree with, but we're going to use the phrase, Kurt and I are going to use the phrase C19. We're not going to use the disease it represents because every so often our host of this, forum listens, being YouTube, listens and sanctions us. So we're not
They're
going to mention
bots.
the
Yeah,
word.
their bots listen to what we're saying, and hopefully things have gotten a little better. I believe over the last couple of months, but we'll see. So we're not going to use that word anyway.
But I'm glad you said that because that things have gotten better. Because before we talk about this $950,000 settlement, I want to remind people it's not where we are today, which was unfortunate about this settlement. It's where we were the other day. I want everyone to sit here and think back to the C19 days when things were crazy. We were saying C19s carried on dog hair, and we had the pictures of at band in school, students sitting playing their instruments in these little protected shells, and kids in school sitting in, these little bubbles. I want that craziness made sense at the time because we didn't know. So before I talk about this very quick, but I want people not to think about this case today, looking back with what we know, don't know, thought we knew, were lied to, were not lied to, but remember it back during the days of absolute hypothermia craziness. So here's what happens. And I'm just offering my 2 cents, but EMS providers in PA, there's a wrongful death suit, and they went to a home of somebody who was experiencing C19 symptoms. And they said to her, we can take you to the hospital, which is important. I can take you to the hospital, but they will just bring you back home. If I was you, I'd stay here. They're asking people to stay home. Your best chance is to stay here. Now, stop for a moment. If this was today and somebody's having a heart attack, you're like, the hospital's real busy. I don't think you should go. Okay, that'd seem crazy today. But back then, ERs were flooded with people. They had no way to treat you. They didn't have any, real knowledge necessarily, right? We're talking in 21. So when they died, so maybe we had a little more knowledge than in March of 20.
Yeah, but it's
certainly.
still, I still think we went through a couple of periods, and there was some problems in 2020, but 2021 is really where a lot of emergency rooms were full, and we were just telling people, you're better off staying at home. Many fire departments were saying that to people. Now, obviously, if you're starting to turn blue and you're really in respiratory distress, that's a different situation.
Which is not what they said. They said the condition worsened the following day. Well, wait a minute. That's not the same condition you had when we visited you and gave you that advice. And I'm betting I don't know, but I'm betting these EMS providers said the same thing I've said for 30 some odd years. If you get worse, please call us back. We will come back.
Right. Now, there were some factual questions, though. Apparently, they did have, I believe it was a pulse ox on her, and her pulse ox was low. There were some family, the mom, I think her mom was a nurse. I forget all the details, but there was enough there to suggest that maybe the initial crew should have done a little bit more. Again, these are factual questions. These are factual questions
but the
here.
Allegations, they never refused to take her. They gave her their opinion, not advice. That's a fine line, right? Because paramedics don't give advice. They don't diagnose and treat. They don't give medical advice. They give their opinions, basically. But I take you to...
I think this was a situation where the junior person ended up going in and the senior people that had the skills stayed outside. I think that was, there was a couple of moving parts here. And, maybe it should have went to a jury. I mean, maybe, to fully understand that. But I think there's a couple of, to me, the biggest causation issue is the fact that she waited another day and then said, I'm bad enough, I need to go. And then at that point, it was a little bit too late. Whereas if she had gone a little bit earlier, but again, that's a little bit of hindsight there.
But if they really did have a nurse there, for example, I'd say, wait a minute.
Nurse was on the phone. We'd have to go back through the facts again. And again, I might be mixing this up with some other cases, but I think there was a family member who was a medical professional that tried to talk to the medics and say she needs to go. And
I definitely remember some of those cases. I don't remember whether this is that or know if that's that, but I go back to the opinion. I can take you to the hospital, but they will. He didn't say, or she didn't say, I refuse to take the hospital, or you can't go to the hospital.
Let me just read from this is from what we have here. The attachment is the court memorandum approving the settlement. Okay. Now, again, what we're dealing with here is an estate. So the court is not willy-nilly going to accept that. They want to go through their analysis to make sure it's an appropriate settlement. But 2 teams of paramedics were sent, including an advanced team, but only 1 junior paramedic evaluated her. And the factual, let me go through it here. Yeah, her sister tested her blood oxygen level, and it was detected to be very low. The woman called her mother-in-law, a registered nurse, who instructed her to call 911 and that she should be taken to the hospital. So there was some family medical connection here, in a sense that the fire department and the medics should have honored those types of requests.
Yeah, and I just don't see a refusal to do so. I just see an advice not to go based on
Right.
these statements. I would stay here. Okay, it's not saying you have to stay here. We don't take you. And then there's a whole refusal release form, I presume. In any event, look, this was a settlement. Both sides determined that it was worth settling. I just say, I don't know. I mean, there's legal fees on top of the 900,000 of $300,000. On my best day, I haven't spent, 2/3 of that or a third of that. I'm shocked, but nonetheless, this is, this is now, not that we haven't seen the C-19, stories. They've faded, but they haven't gone away. And this is just, wrapping up that era. But I think it's unfortunate because you have to view C-19 as it was during that time, not rationally now when whatever we know or don't know.
Right. Yeah, no, and I believe I'm thinking that the plaintiff in this case, the plaintiff in the case is a fellow firefighter attorney, Ed Robson. So he is a colleague, and so he was the plaintiff's attorney in this case.
Wow. I mean, that big money in legal fees. I mean, 300,000, a lot of money to spend. I'm not.
Well, I'm sure some of that's got to be costs. You're going to need experts, and I'm sure there's costs, but it's roughly a third of the overall settlement. So,
and by the way, I love the attorney. He's a pilot, right? As I recall, I love the attorney. He's the nicest guy you'll ever meet, and kudos to him in the settlement, right? But my 2 cents is, wow, life was crazy then, and this just reflected the craziness of what we were telling people. If you're not having symptoms or they're not bad enough, stay home. And what the heck does a paramedic know at the time? I don't know. Anyway, but kudos to our friend. I've stayed in touch with him for a little bit. He's a great guy. He used to lecture at FDIC with you guys, I think. And so great guy. Anyway, okay, not again, kudos on that huge victory. Lastly, we are going to Louisville, who's revisiting policies on their driver's license checks. I don't know why we're revisiting the policies. Why do you not have a policy that says you have to have a driver's license to drive an emergency vehicle, nonetheless to drive to work? I don't know how to comment on this.
Yeah, I think you got to watch the whole video for those of you who are out there that scratching your head on this one. But apparently he had some issues in the past about having a driver's license, and they thought they got those resolved. And then a second issue happened, and there are departments out there that do periodic license checks for all members.
In New York, everybody does automatically because the DMV has a program called Lens. I don't know if this is National Licensed Event Notification System. And if you even have a suspension, a ticket, an email goes out to the chief.
Yeah. And some departments, the registry in some states will allow some departments to track points, track their driver's license points, which is another factor. I mean, the last thing you want to do is you have a serious or fatal apparatus accident, and then you find out your driver's license or your driver, high points, or the license was suspended and you were not aware of that. So,
no, go ahead.
Those types of things are problematic. Now, some states, they don't share that information, so it's not possible to access it, but you can still put a mandate on your firefighters that they've got to notify you that they don't have a license.
And one of the things I want to say in a law practice, I had this a couple months ago, and it's not uncommon. I get calls even from my past clients, right, where I've handled a traffic ticket for them. It's been dismissed. They paid the check. I have all the paperwork and I closed the file. And then 3 years later, you get a call. I just got pulled over and arrested because my license was suspended. I'm like, for what? They said non-payment of the fine. I said, they cashed your check. They said, well, they didn't enter into the computer. So people may not know. They think they're fine. They don't know. Look, and when I was chief, I probably had 2-3 people over a couple of years where I'm like, your license is suspended. They're like, how? And they literally didn't know. They weren't trying to pull one over. It wouldn't matter to a jury because that's the department's negligence, but everybody needs to check licenses. You know what? That should be our next policy. Everybody on must-have policies, everybody needs to check license. You have to check licenses. If your state doesn't offer a system, I don't know how you do it, but do it anyway. You're right. The liability is huge.
Yeah. So
that are our cases. Those are 5 totally different new cases on things. And if there's one point, just to go back to it, if there's one point we could revisit just as we close, because I think it was such an important point, is talking about the retaliation, and that
Yep.
the person who's, your biggest problem is likely looking, in my opinion, looking to trip you up and get you to make a mistake that and they'll report 100 things. Only one has to be valid. And then you take action against them, even if it's for some other misconduct. But now you're in that McDonnell Douglas proving, well, I disciplined them because of what they did over here, not because of their retaliation. That's a jury question, or because of, what they complained about. That's a jury question. And that's going to be settled by the insurance company. So they are just teeing it up for you. If you don't if you retaliate, you're done. If you don't investigate, right? That point is so clear that these people are trying to trip you up. Don't let them get under your skin. Treat everybody the same way. Your point was so well made. We cannot emphasize it enough.
Yeah, and I think the retaliation problem is not just the administration, the fire department administration retaliating, but it can also be the colleagues. And you have someone who's maybe got a difficult personality, and they're doing things in the station, and then there's some peer pressure applied to that person. That person then in turn complains, and everybody knows what's going on. They know that this person's got a difficult personality, but the complaint is out there, so now the department needs to investigate that. You can't soft shoe it. You got to do the investigation. But in the meantime, while this is going on, the peer pressure ramps up. That is retaliation as well. And that's why we have, well, not why, but we have company officers at the company level that need to get involved in this and keep the retaliation from happening. Because if that retaliation does indeed happen, you're giving that problem child the keys to the kingdom here, or basically a blank check to write their own award. So we've got to make sure that we're prepared for dealing with retaliation, both from the administration, but also from peers who may be upset with someone who's filed a complaint.
Yeah. And said rightly, the captains and lieutenants are some of your worst, not enemies, your worst problems sometimes, because they're still one of the boys, one of the gang a lot.
I don't think they understand the retaliation component. And once they grasp it, they're like, you're upset with this person. This person's filed a complaint, maybe against you, maybe against some of your other subordinates. If you're not happy with them, then you better get the retaliation to stop, because otherwise you're going to reward them, because they're going to be able to now prove retaliation because all the other things that are going to happen at the company level.
Right. And, for everybody's knowledge, it's one thing when a run-of-the-mill employee does something wrong, like retaliate or discriminate or make a comment, right? Mm-hmm. That's not a problem until the employer finds out. But your captains and lieutenants are officers, and they are 100% strict liability for you, meaning when they violate the law, when they retaliate, it's done. There's no question of what action you took. They hang you right there. Yeah. And that's a scary thought.
It is, because a lot of times company officers, lieutenants, and captains don't think about themselves as part of management. But when it comes to number one, discrimination, and number two, retaliation, they very clearly are. And when they become aware of it, it's as if the fire chief is aware of it. It's the same continuum. Yeah.
Yep. So please be careful. It's maybe why we should have some more legal training for the company officers. Right. Mm-hmm. Not just the chiefs. You and I, we focus so much on the chiefs and the administration, but like when we talk about family medical leave, we talk about the person picking up the phone on the phone call and hearing from the person, oh, I'm going to be sick today. And they hang up and do nothing. And they took that same phone call 10 days in a row, and they still do nothing to notify anyone. They're creating the liability for you. So these people are creating the liability for you. There should be some training. Please don't just limit these types of conversations to your chief officers. Have them with your captains and lieutenants. They are the department as far as liability is concerned. Yep. So that's it for this week.
All right. That'll do it for another edition of File Law Roundup. We'll see you again next week.